And I paid him. Yes, it was. He said he'd take it in payments, but I paid him all in full early before we even took the car. So, I don't see how it was true. It was 200 here, 400 here, 500 there. Yes, but he was paid in full before we even got the car completed.
And I see Ms. Langston has turned on her video. I'll put both of you under oath. You want to raise your right hand? Do you both swear from the testimony that you'll be providing will be truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Yes, I do.
Thank you, Ms. Langston. I'll hear from Ms. Langston first, and then I'll turn to you, Mr. Mendoza.
Okay. So I originally called.
Hang on just one second. Let me pull out the case file.
This case starts the way a lot of small claims disputes do, over money, but very quickly turns into something much bigger. What you're about to hear is a battle over trust, responsibility, and what happens when a professional tells a customer, your car is ready, and that turns out not to be true. On one side, a vehicle owner who says she paid in full, relied on the mechanic's expertise, and drove off believing her car was safe. On the other side, a mechanic who claims the engine was already damaged long before the repair was finished. The stakes? Nearly $10,000 and a completely blown engine. As always in court, the truth isn't just about what broke, it's about who knew what and when. Pay close attention to the timeline here, because the sequence of events is going to be everything.
At Mecca Automotive to see if he could come out and do a diagnostic check on my car to see what was wrong with it and what needed to be repaired. He agreed that he would come to my house and, put the diagnostic check in the car to see what was wrong. The findings from that were that the oil pressure sensor was not working. So we agreed that he would come back and replace that part. Then once that part was completed, we determined that from there that the oil pump was not working.
This is the judge officially framing the case, and that's an important moment. The claim isn't vague and it isn't emotional, it's precise. A specific dollar amount tied to alleged negligent service resulting in engine failure. That tells us exactly how the court will analyze this dispute. This isn't about inconvenience or dissatisfaction. It's about whether a professional mechanic failed to meet a reasonable standard of care. The judge is also confirming that both parties are present and under oath, which means everything said from this point forward carries legal weight. In small claims court, credibility often matters just as much as documentation, and how each party presents their story can make or break the case.
We agreed that he would work on that to replace the oil pump. My car, originally the reason why I had called, because when the car started, the engine would immediately give a warning light that said it was the engine oil was hot. Not that the car was overheating, but the engine oil was hot and to immediately turn it off. So the car had to be towed to Mecca Automotive for him to work on it. He worked on replacing the oil pump, drain all the oil out, replace the new pump. And that from there was a couple other things that had to be done, like the oil had to be put in, some additional seals and stuff had to be replaced from, taking it apart to repair. Once that was all done, this ended up being around June 10th. I was called and said the car was done and it was ready to go. The engine was on and it was running. When I got to Mecca Automotive, the engine was already on, the car was on, and Edgar said he needed to take a test drive. So he pulled out on the street, went hardly anywhere at all because he was back within 5 minutes, and you could hear that he had just gone down the street, like maybe a block or two. He came back and he said, okay, everything seems good to go. You can go ahead and take the car home. It's done. I had already paid him in advance for the replacement oil, the oil pump, and all of that work that needed to be done prior to him calling me and saying the car was ready to be picked up. So I left that day, got in the car and I left, and I went approximately 500 feet down the road, and my car started making a very loud pinging and clacking noise. So I called back to my significant other, Aaron, who was there with Edgar, and said that the car was making noise. So they immediately told me to bring the car back, which I did. I turned around and I was back probably within less than 5 minutes. I was not able to go very fast, and the farther I was driving, the louder and louder the noise was getting. So when I pulled into back to the automotive shop, they said that Edgar said it sounded like I blew a rod in my engine, and that he would have to look at it further from there. So within the next week, he called me back and said that it appears that the engine oil was not pumping through the engine, which caused it to continue to get overheated. The oil got too hot and the bearings melted and blew through the engine, causing the engine to no longer be eligible to drive. So we called several mechanics at the same, other mechanics, to find out what they thought was wrong with the car, why it would be making that noise. And they all agreed that what would make the engine start making that clicking and clacking noise was the oil was not going back through the engine like it regularly should. So we
called
the
it was not reading. They said good to go.
There was a mechanic next door that had told us that he checked it with one of his tools that checks whether the oil is pumping through or not. And he said that the oil.
This moment is a turning point. According to the plaintiff, the mechanic didn't just fix the car. He tested it, turned it on, and told her directly that it was ready to be driven. Those words matter. When a professional releases a vehicle and tells a customer it's safe, the customer has the right to rely on that representation. The fact that payment was already made in full strengthens that reliance. There's no outstanding bill, no unfinished work, no warning attached. From a legal standpoint, this is where responsibility potentially shifts. Once the car leaves the shop under the mechanic's approval, the mechanic may still be accountable for what happens next, especially if the failure happens immediately.
The bearings blowing through the engine was my fault for driving in the car. So at that point, there was obviously going to be no agreement. Edgar was not willing to help nor pay pay for anything that he'd already done. That was negligent work. And so that's why we filed the small claims. Now, when we were in the mediation room, Edgar mentioned that it was just people trying to rip him off for work done. Well, I had paid him in advance before I was even told the car was done and ready to go.
Langston, you have said that you paid him in advance a couple of times. What was that? That advance was for the repair, and how much was that?
That was for the replacement of the oil pump, the oil pressure extender, timing port, cover. The total was 2,000. Sorry, the invoice is really hard to read. The total invoice was for $2,700, and I had paid him in advance. The reason why the claims is for higher than that is because now my engine is not usable. It needs to either be replaced or rebuilt. So I have an estimate for the cost to rebuild the engine, and that's where the amount of the claims came from.
Okay, and your claim is asking for $9,860, and your paid in advance was $2,700 for repairs. Is this $9,860 based on your value of the car? Is that what you're claiming?
No, it's based on the estimate I have for the rebuilding of the engine. The rebuilding of the engine sorry for my dogs. The rebuilding of the engine is $10,162. We owed significant other, Aaron, owed Edgar for some other work done on another car, which we just subtracted from the estimate and figured that, we would claim that.
The timing here is devastating. We're not talking about something that happened days later or after extended driving. We're talking about a mechanical failure that occurred almost immediately, within a few hundred feet. That kind of rapid failure raises serious questions about whether the vehicle was ever road ready at all. The fact that the noise intensified the moment the car was driven suggests that whatever went wrong was already in motion. Courts often look at proximity in time as a clue to causation, and this sequence strongly supports the argument that the problem existed before the car left the shop.
That amount. It's a little less than the engine rebuild.
And then you refer to a mechanic who told you, who is that mechanic that you're referring to? And do we have any evidence that you have provided in terms of his inspection?
You were going to submit whatever you.
I'm not talking to someone else other than you, Ms. Langston.
Okay.
The other person is not under oath.
Okay, it is, the mechanic is, his name is Robert. He works at radioactive fabrication, and it is a building adjacent to Mecca Automotive where Edgar Mendoza works.
Thank you.
He
Do you have
specializes.
anything else to add?
He specializes in working on LS and LT engines, which is what one in my Camaro. And I feel that he was there and was also helping with the replacing of the pump. And, he has information that seems valid. I did call other mechanics as well as Chevrolet, and they all said the same thing, that the oil pump not going through the engine is what would have caused the bearings to be shot through the engine.
Is that it?
That's it, Your Honor.
Go ahead, Mr. Mendoza.
Thank you, Your Honor. Just want to say, Mr. Kiska and his wife contact me around on the latest of June to check on their car after
June of this year?
this year, yeah.
Okay.
After I done another repairs on one of the other vehicles for Mr. Kiska, his spouse. And well, I checked the car over his location, and I know that what she stated, the car showing all the signs about oil pressure. There were like a Christmas tree with all the warning signs lighting up. They said somebody else has been working on the vehicle, and they mess up with the electronics and some stuff at the computer. Still, the car was able to crank it, but I hear there was something going on at the very beginning. So I just said, well, might need to take the car to the shop because over your place, there's nothing I can do about it. I'm not gonna drive it because sounds like there is problems. The warning sign is telling low oil pressure, so stop driving at the very beginning. So they towed the vehicle over my shop, and all down over there, still was no idea exactly what was going on. The first thing I did is drain the oil in front of Mr. Kiska. He was there, and the oil came out with metal shavings. That was the first sign.
This is where cooperation collapses and conflict hardens. According to the plaintiff, the mechanic didn't offer a solution, a repair, or even partial responsibility. Instead, he placed the blame entirely on her for driving the vehicle, despite allegedly telling her moments earlier that it was safe to do so. From a legal perspective, that's a dangerous position. A customer cannot be faulted for following a professional's instruction unless they were clearly warned otherwise. If no warning was given, no disclaimer documented, and no refusal to release the vehicle occurred, the responsibility may not be so easily shifted.
I think telling, on the warning signs. So, okay, well, you want an oil pump replacement? That's what you got. That's what I did. I get a new pump for him, install it. Unfortunately, in order to do this, you have to do pretty much the whole surgery. I have to spend 5 hours to access to this thing. After I access to this thing, I got a new pump, installed it and everything, got primed with all the procedures, sealed the timing cover of the engine. I didn't open the whole engine, just the timing cover. and put everything back together, the water pump and the rest of the accessories. I crank it up. We cranked it up the car. He was there, and the car was running really rough. That's the reason they called the mechanic next door, who was specialized on these kind of vehicles. They did another repair on the intake manifold of the car because the car was running low RPMs since who knows. So the mechanic did this modification and make the car running properly again with the proper RPMs. And that was the part of my my neighbor next door. No? There's two shops, mine, regular shop, and the specialized racing shop next door. That's the only thing he did. He didn't put his hands more in. He checked the car, and the car appears fine, but it wasn't because all the signs are still there. The warning signs, all the lights in there. So at the time we crank it out the car, immediately, as soon begins to run normal, begins to make clacking noises. Mr. Kiska get into the car and step on the gas pedal and rev up the car all full throttle. And he also took a video and sent it to his wife. I was laughing, blah, blah, blah. He's ready. And I said, well, he's ready. He has been paid. He paid me on payments. He never paid me on advance the 1,700. He just gave me 200, 400 till I complete the repair. So when I delivered the car to them, they were there.
Here's where the case moves from storytelling to hard evidence. The plaintiff explains that the claim amount isn't arbitrary, it's based on an actual engine rebuild estimate. She also clarifies that she's not claiming the full value of the car, but rather the cost to restore it to working condition. Judges appreciate clarity like this. It shows preparation and intent, not exaggeration. By grounding her claim in documented repair estimates, she's framing the damage as a direct financial consequence of the alleged negligence, not just an emotional grievance.
But the car has the problems still. Was cranking, was running, but still I hear the noises immediately. So as soon she get into the car and drove out of the shop, he rubbing tires and everything. He went out the road. Not even 5 minutes later, we received a phone call to his husband, and she stayed like, oh, the engine is making tapping noise, blah, blah, blah. And I told him, well, bring it back to see now what else. And they brought back, and she drove back to my shop. The car, of course, they've been doing more louder noises. So to get this this is the old pump. To get to this point, to get scratched and overheated, it's even blue with groups inside. You can tell has been friction and overheated. When I got to this point, I have to have it outside. I opened and I realized all this. But that was obvious to me from the very beginning when I drained the oil. There were problems prior I put my hands into the car. So they just asked me to do the oil pump replacement. That's what they got, oil pump replacement. I didn't rebuild the engine. I didn't open the rest of the engine. They have electrical issues. And that's how it turns. I tried to explain them, because whoever works in the car before, they mess up with this thing. This doesn't get shot in 5 minutes. This takes some time. The car was, I run a Carfax, I have it here. And the last service, it happened on Stonewater Automotive. I have it here when the car was 528,000 miles. When they show up over my shop, the vehicle had 67,000 miles on it. So we are talking about almost 10,000 miles from the last service till they show up to my shop to get it repaired. All this time, the car has been parking over their house for the last 7 months, probably, or 6 months, something like that, because they were really, with mold and stuff, spider webs and everything. But they knew already they have a problem. So they just been looking to find somebody like me, trying to help them out. And now this is where I am. I've been doing this for 25 years in Thurston County area. I think I've been here 2 times in all these several years. And unfortunately, they don't understand what happened with their vehicle. Somebody else messed up with this vehicle, and now here we are. That's the only things I can say. Well, I have the